Age discrimination in the workplace by Georgadze. The Age Discrimination in Employment Act. The Federal Age Discrimination in Employment Act, or ADEA, is a primary federal law that prohibits employers from discriminating against employees and applicants who are at least 40 years old based on age. The ADEA prevents age discrimination and provides equal employment opportunity under conditions that were not explicitly covered in the Title VII of the Civil Rights Act of 1964. It also applies to the standards for pensions and benefits provided by employers and requires that information concerning the needs of older workers be provided to the general public. EEOC versus Sidley Austin. EEOC alleged that an international law firm violated the ADEA by implementing and maintaining an age-based retirement policy and by downgrading or expelling from its partnership certain partners age 40 and older because of their ages. A consent decree provided $27.5 million to 32 former partners and prohibited defendant from terminating, expelling, retiring, and reducing the compensation or otherwise adversely changing the partnership status of a partner because of age, maintaining any formal or informal mandatory partner retirement policy or practice based on age, pressuring a partner to change partnership status or to retire because of age, requiring partners to cease their service on any firm committee or as a practice group head because of age, or taking retaliatory action against any person for conduct related to the case or the claims in the case. Owen versus ST Microelectronics. In this case, Mr. Owen worked in an in-house counsel role at ST Microelectronics. After a short stint at STM from 2007 to 2008, he returned to the company in 2013 in a paralegal role. Opportunities at STM opened up for junior and senior attorney positions. Mr. Owen expressed an interest in the senior position, but was told that STM did not want someone with so much experience that they would be inflexible. STM advertised for the senior role seeking someone with about 10 years of experience. Mr. Owen applied, but was unsuccessful. Mr. Barrett was hired instead, who at 36 years of age was substantially younger than the 64-year-old Mr. Owen. Mr. Owen's paralegal position was subsequently eliminated and he found himself no longer working at STM. The court said that there was enough evidence to go to trial. While the company may not have intended to discriminate against older people, the language used could be indicative of age discrimination. Unless it settles earlier, the case will now proceed to trial. This case highlights the dangers around the language used in recruitment. Words and phrases like digital native and energetic can suggest a bias against older workers, whilst gravitas can suggest a bias against younger workers. Kenneth versus Barnabas Health System. In this case, the Third Circuit Court of Appeals has made an interesting decision about harassment in the workplace. In this case, the claimant, Mr. Kenneth, has retired from the military and began working as a registered nurse at the hospital. He brought a claim of age discrimination in relation to an alleged age-related hostile work environment. He cited as evidence he was told he didn't understand how the office printer worked, that he had been laughed at for inadvertently answering the phone using his military rank, and his being forced to take retraining on basic nursing skills. The Third Circuit held that he had not experienced a hostile work environment. The incidents Mr. Kenneth experienced were simply annoyances. Accordingly, the Third Circuit dismissed Mr. Kenneth's claim of age discrimination. The cold, hard truth about ageism in the workplace. 58% of workers notice age bias when people enter their 50s. In 2017 alone, more than 18,000 age discrimination complaints were filed. 7% of people report losing their job due to age discrimination. 1 out of 5 workers aged above 40 report not getting at least one job due to age discrimination. 77% of workers who are black experience ageism. Age discrimination affects everyone. As we can see, age discrimination in the workplace is still a big issue in the United States. For the moment, this situation is going to be worse. By 2024, workers aged 55 and older will represent 25% of the nation's workforce, with the fastest annual growth rates among those aged 65 and older. Indeed, according to the Hiscox survey, 67% of surveyed workers aged from 45 to 65 plan to continue to work after they turn 66. Age discrimination hurts not only employees but employers as well. This situation hurts employers in two ways: financial and declining in product quality level. Every year, employers lost $810 million paid in settlement costs. But another problem that age discrimination demotivates employees, which hurts customer services and product quality. It causes a loss of talent and institutional knowledge due to experienced workers leaving from a stalled career or hostile environment. I hope that the government will pay more attention to this problem and will find a solution to make it better.